Thank you. Hold on just a second. I want to share some PowerPoint slides. Um, Great. So I was going to talk to you today about judicial power. Um, Let me back up one slide, though, actually. So this summer, I'm going to be teaching constitutional law in our non-degree program. Constitutional law is one of my main courses. And in the course, we cover two main subjects: the structure of government and then individual rights. So the first half of the course, we're looking at judicial power, legislative and executive power. So we're looking at the structure of the federal government, how it's put together, what it can do, and of course, separation of powers, how the different branches interact with each other, and the state governments. So the Constitution essentially creates a blueprint for the United States government, and the Supreme Court interprets that, creates law out of the Constitution that then essentially is a framework for our government. Second half of the course is individual rights. We look at things like the First Amendment, freedom of speech. That's a big right. The Equal Protection Clause, the Due Process Clause, important protections against discrimination or arbitrary governmental action. I thought today it would make the most sense actually to talk about judicial power. Given what's happening in the headlines with the Trump administration and the Supreme Court, it seems as though there's a bit of a conflict brewing between the court and the president, and a real constitutional crisis that people are identifying. So I thought I would try to provide some context, some history of how we got here, what the courts are doing, and their power vis-a-vis the president. So I'd like to start at the founding. In the course, I start in a different way. I give a historical presentation about the founding so that you understand the Constitution, its context in which it was ratified, and then we talk about how the court interprets the law, the methods of interpretation, and there's some framing around this. But this is the first unit in the course, right? So by the end of the first class period, we would end up here. And so I'm going to just start jumping right into it with the power of the courts. So the Constitution creates the three different branches of government. It gives them their powers and it limits their ability to act. Now, the Supreme Court is created, the federal courts are created in Article 3 of the Constitution. They're the third branch, right? Congress is Article 1, then the president is Article 2, the Supreme Court is Article 3. And it's put in there as the third branch because the founders think it is the least dangerous branch. Alexander Hamilton, a very famous founder, you may have heard of him. There's this famous musical on Broadway about him now, and his role in the founding of the Constitution. And he tried to argue that the courts aren't that powerful because they can't do anything on their own. The courts simply have the power to issue decisions and try to convince people of their reasoning, but they don't have the power to do anything. They can't throw anyone in jail. They can't spend money like the other branches. So, in a sense, they can only do things if the rest of the country agrees with them and are willing to accept their authority. However, the anti-federalists, the people who are arguing against the Constitution, they argued that no, the Supreme Court is dangerous. It is the biggest threat to liberty because if we give the court this power of deciding whether federal law is valid, if we give them too much power, they could get out of control. That is because federal judges under the Constitution have lifetime tenure. They can only be removed through impeachment, which is a process that is really hard, and it's never been done for a federal judge. So the concern from the anti-federalists is the court is not accountable, they're never up for election, and if they have too much power, then they could really run the government. Uh, One of the key questions in the course really is, were they correct? Does the Supreme Court have too much power? Is the Supreme Court using that power in a wise way? This really starts in 1803, right? The Constitution is ratified in 1788. So not too long after ratification, right? Very early history. So our second president, and maybe I should back up here a second and explain, in the United States, we have a common law system where the law, in a sense, really comes from court cases. And so it's important to cover these court cases so you understand what the law is. Sometimes there are statutes or constitutional provisions that are relevant, but you always need to read the cases to understand what they really mean. So this very early case tells us about the power of the courts. Just to set it up a little bit so you understand what's going on, this is the most famous case in all of constitutional law, Marbury versus Madison. It is foundational. In this case, we have President Adams appointing a bunch of judges as he's leaving the presidency. So he loses the election to Thomas Jefferson, the election of 1800. As he is leaving office, he signs a bunch of appointments creating new judges. Thomas Jefferson is not happy about this, right? That Adams is trying to create these Federalist judges that are going to block his administration. So Jefferson just does nothing. Adams doesn't get all of the commissions delivered to the judges. So he signed these things, he's created the judgeships, but the paperwork never gets out. And at least this judge, Marbury, is never given his commission. And so the President Adams has said he should be a judge. The paperwork is all filled out, but it hasn't been delivered to him and he doesn't have the commission, so he's not yet a judge. The court ends up saying here that is illegal. The president has an obligation to deliver the commission. Really, James Madison, the Secretary of State under Thomas Jefferson, has an obligation to deliver the commission to Marbury because the president, President Adams, had signed it. There was nothing further to do. He had a legal right to it. The key holding, though, is that the court can't do anything about it. Now, that might sound weird because this is a case about judicial power, and the Supreme Court is saying it doesn't have the power to do anything. But it's actually very significant because in doing that, the court says that a federal law is unenforceable and unconstitutional. And that is the federal law that really grants the court jurisdiction in this case. I don't want to get into the weeds and the nuance of it. Just trust me on this. It's a technical issue of jurisdiction. Does the court have the power to hear the case right now? Or does it need to wait until the case is appealed up from the lower courts? It's an arcane technical issue, but the key holding here is that the Supreme Court gets to decide whether a federal law is valid. Now, the context is important. I gave you that story for a reason. The court is doing this in a way to where President Jefferson cannot ignore them, right? Jefferson can't refuse to enforce an order when there's no order. So the court says, Jefferson, you're wrong. You're acting illegally. We get to say what the Constitution means, not you. But there's nothing we can do right now, right? So they have this shot at Jefferson, but nothing really happens. Their justification for it is important. They say the Constitution gives the courts the power to interpret and apply the law. The Constitution says the federal courts, the Supreme Court, needs to decide all cases under federal law. The Constitution is supreme. It tells us that. There's a clause in the Constitution that says if there's any conflict with the Constitution, it wins. It is supreme in authority. It is stronger in authority than a federal law or a state law. A federal law derives its authority from the representatives in Congress, whereas the Constitution derives its authority from the people themselves. And in our system, the people are supposed to be sovereign. The power of government flows from the people. and therefore the Constitution has a closer link to the people, to political power, and therefore it should it should have higher authority than any federal law. And the Supreme Court, because it has the power to decide what the law is, they have the final say on what it means. Essentially, it gives us our basic framework for the hierarchy of law within the United States, where state law is at the bottom, then federal law, then the people, right? The idea here being that state law is trumped by federal law. If there's a conflict between the two, federal law wins, the state law is invalid. That's a topic we would cover in constitutional law called preemption. When is a state law invalid because of a conflict? Judicial review is using the Constitution to strike down both. And the real argument for judicial review is this policy argument, where the court says, what good is a written constitution without judicial review? It would be meaningless, right? The Constitution creates this structure. It limits governmental action. It limits governmental power. But if the courts do nothing and just let the president and Congress do whatever they want, the Constitution is meaningless, right? And that can't be right, because the founders and all Americans, basically back to the founding, have always thought the Constitution mattered, that it meant something when we ratified the text. It's not the English system where we have this history, but not a written constitution with these vague sort of rights. No, in America, the system is supposed to be different. And the only way to have a written constitution matter is to enforce it. Someone has to enforce it, and it should be the Supreme Court. That's sort of the logic here. The next case that comes along, and we would spend a lot more time on this in class, I'm giving an overview here. The next case is about whether the Supreme Court can hear decisions coming from state courts. The states tried to say, look, we have a different system, right? States are separate from the federal government, so there's no overlap. The only point I wanted to make here is that the Supreme Court intervenes in another very early case. Martin versus Hunter's lessee is in the early 1800s, and the court says, no, the Supreme Court can hear appeals from the state system because otherwise we would not have a uniform interpretation of federal law. Uniformity is sort of the key here, right? If the Supreme Court can't decide the meaning of federal law, then there will be no uniformity. Federal law will mean one thing in New York and a different thing in Dallas, right? That would be a very bad system. You wouldn't want to sign a treaty with the United States and have Texas interpret it differently than New York, right? So we need one body to decide these issues. And of course, that ties into Marbury versus Madison, right? We need the government to speak with one voice. And on legal matters, it makes sense that that should be the court, not the president, not Congress, and certainly not the states, right? The next case in the series here that I want to present, the last case, is Cooper versus Aaron. So I could talk about this one for hours. I mean, honestly, I could talk about each of these cases for hours, but Cooper v. Aaron, I think, is the most interesting comparison to today. Cooper v. Aaron is a case that tells us that the Supreme Court can not only decide individual cases and tell Congress it's wrong, or the president that he's wrong in individual disputes, but that its interpretation of the Constitution is always binding on the entire government. That's what this case stands for. And that's a pretty big evolution, right? In the early 1800s, that's not what the court was saying, right? John Marshall, Joseph Story, those people I had in those pictures a minute ago, that's not really what they were saying. What they were saying is that the court has the power to decide cases no matter what, and they need to give a uniform interpretation of federal law so the government speaks with one voice. They didn't really say, though, that their decisions are binding on everyone no matter what. No, the court has the power to decide cases. They don't have the power to make law, right? the power to make law comes from Congress. So this is a little bit controversial, and you can see the president today, President Trump's administration, essentially is pushing back against this and strongly suggesting, without saying it out loud, that Cooper v. Aaron is wrong. So I think it makes sense to talk for a second about the context of Cooper v. Aaron, give a little bit more of an understanding here. So in Cooper v. Aaron, we had this was part of the response to Southern defiance of Brown v. Board of Education. This is the biggest thing the Supreme Court has ever done, at least up to this point, probably in its history. So as everyone knows, right, the United States has a long, troubled history with race relations. It had slavery for its first period before the Civil War. After the Civil War, we abolished slavery, but there's a lot of history here, but fast forward a little bit, we get a system of segregation, right? Where the government was telling white people they got to go to these good public schools and telling everyone else, especially black people, that they had to go to these inferior and different schools. In 1954, the Supreme Court finally said that's unconstitutional. You can't do that anymore. You have to treat people equally. Constitution says equal protection under the law. However, the southern states, especially the Deep South, was very opposed to this. They thought the Supreme Court was wrong, and they defied the court for decades, right? 1954 is the decision. We don't have the Civil Rights Act until 1964, and we don't achieve meaningful integration until Congress acts in 1964. So for about a decade, and then longer, because it takes a while for them to comply, for about a decade, the Supreme Court was being ignored in half the country. That's not a big exaggeration. The Supreme Court was being ignored in almost half the country for about a decade. The Supreme Court intervened here in the middle of this period to support President Eisenhower. President Eisenhower went in to desegregate the schools in Arkansas because the Arkansas government was saying the Supreme Court was wrong. The Arkansas legislature passed a statute saying segregation is good, the court is wrong. The governor was putting state troops outside of the school saying that black students were not welcome. And so President Eisenhower sent federal troops in there, General Eisenhower, he was the general for the Allied forces in World War II. Right? He was not going to take armed resistance from the governor of Arkansas. So he sent federal troops in there. They got the kids in school, and he enforced the court's understanding of the Constitution. That's when this decision happens, right? The court says federal law is supreme. What we say goes. States, you're not allowed to disagree with us. And in saying that, they say that Constitution is supreme. We, the court, are supreme in saying what the law is. So every government official must immediately follow what we say the Constitution means. That is the strongest version of judicial power. And again, that's controversial. Many people, apparently our vice president, especially maybe our president, think that that's not true. They think that, well, no, each branch of government gets to interpret the Constitution equally. Nothing in the Constitution says the court is special. That's true. Nothing in the text of the Constitution says that. But for the last 200 plus years, that has been the trajectory of US law, right? And it's based on this idea for we need a consistent interpretation that is uniform throughout the country. We don't want Arkansas to do one thing and Virginia to do something different, right? And since we need somebody to create uniformity, it should be the court, not the president. We can trust the court more on matters of law, and that they're going to have a better decision. It's going to be more reasoned. It makes more sense than to have a political actor do it. Now, of course, the argument against that goes all the way back to the founding. I started by saying Hamilton said the court is not dangerous. It can't do anything unless the other branches obey voluntarily. Well, no, the anti-federalists, the other side said, no, you're wrong. They're unelected. They have all this power. They can they get to create our framework of government, tell us what rights we have, and there's nothing we can do about it, right? There's going to be people who are on the court for decades and decades, and we can't get rid of them. So it's a sort of debate that we've had for 200 years about who really has the final say. And honestly, it's flipped a little bit over time, right? So, to give just a second of history here, I know I'm going a little bit over. Maybe I'm boring you to death. I don't know, but the some history on this. Back Going back in U.S. history, Presidents Jackson, that was in the 1820s, 1830s, President Lincoln, 1860s, they both said, and some others, that they could ignore the Supreme Court if necessary to protect the country, or if the country rejected the court's interpretation of the Constitution. I'd go into a bunch of detail there if you're interested, but that hasn't really happened since then, though, right? That really hasn't happened since the 1860s and until today, right? Until today, when there's a lot of pushback against the Supreme Court's ability to rein in executive power. And this is really coming to a head, I think, in a couple decisions that have come out in the last few weeks. So, in the cases that are raising this most directly involve immigration deportation. So, the decision in AARP versus Trump, this is dealing with the main incident we're talking about here is that the president put 237 citizens of Venezuela who are in the United States on a plane, flew them to El Salvador, and put them in a very dangerous prison. I assume most of you have probably heard of this story. It's all over the news in the United States. And when they did this, though, one of several of the Venezuelans had attorneys who filed a case in a lower court in D.C. The Supreme Court intervened, though, and said, no, that's the wrong court, and suspended what that court had done, said, no, you got to file it somewhere else. So then they did that, and the administration seemed as though it was going to continue to engage in this process of sending people to El Salvador without any sort of hearing to determine whether they should be sent there, right? To determine whether or not they were this terrorist threat to the United States. And so the Supreme Court then intervened just a couple of days ago and said, no, Trump administration, you are not allowed to send anyone out of the country on this basis. You can't send those planes over anymore. And so the Supreme Court is telling the president what to do in a very direct way here. And, that's a big event. It doesn't happen very often. There's a lot of discussion here about this. Garcia versus Nome is, I'm referencing that. It deals with the individual who the government admitted it should not have sent to El Salvador. But if you would look at that, if you're interested and you want to read about this stuff, Google those two cases. Read the most recent opinion. The opinion in Garcia versus Nome, also very interesting, from one of the most famous circuit judges, lower court judges in the country. And what they're talking about essentially is the need for the court to be able to decide what the law means. Going all the way back to Marbury versus Madison. And as the judge in Garcia says, it is crystal clear that everyone deserves due process before they are punished, before they are sent out of the country, before there is a big action that deprives them of life, liberty, or property. There's no dispute about that. And so the president clearly acted illegally when he sent those 237 people, or actually 238 people, to El Salvador. And so the court's intervening and saying, no, you can't send any more. The Constitution clearly forbids that because you would be denying due process. Now, if the court is ignored, though, and the president continues to engage in that behavior, there's really nothing the court can do, right? That's Hamilton's argument. They're not that dangerous. They're not really interfering with the president unless the president voluntarily complies. How is the system supposed to work then if the president is ignored? Congress has the power to enforce the court's orders by stepping in and investigating executive misconduct and impeaching the president and removing him, right? That's the way the system is supposed to work. The court comes in and says whether or not the president is violating the law, then Congress comes in and enforces that law by removing him. Checks and balances, no one branch can do everything. However, unfortunately, let's be real here. Congress, the Democrats anyway in Congress tried to impeach Trump several times in his last administration. It did not work. And Congress does not seem interested in playing its role at this moment. And so without Congress stepping in to do its job, there's not a lot the Supreme Court can do, if I'm being perfectly honest. The best it can do, and what I expect to happen, is for it to insist that it has the power to enforce the law, that it has the final authority, but it's probably, and I think there's a lot of evidence for this, it's going to avoid a direct conflict with Trump because it's worried that it can't do anything if Trump ignores the court, right? And that's the way the system is designed. That's on purpose because we don't want the court to be in charge of the president. We want checks and balances. So if the court and Congress agree that the president is wrong, they can step in and fix it. But that's just not going to work unless Congress agrees. And right now, Congress seems very closely aligned with the president. And so I hope that provides a little bit of insight into what's going on. But obviously, the course in constitutional law would go into more depth, more detail, and cover a lot more additional issues as well, of course. So I'm happy to take questions about this topic, about current events, about constitutional law, about the program. But thanks for bearing with me here. I know that kind of took a while. Yeah, thank you. If you ever want to reach out to me, feel free to email me as well. Thank you.